Yeah. So yes, all of you, now we have a real banker in your class, है ना? So it's very nice that she explained to you, this is the importance of you all interacting in an online session. I wasn't aware I am explaining to a banker the banking laws, है ना? So she had her experience and she spoke it out. So naturally, uh, when such things happens in the bank, for example, if she has given a loan to one of you and that particular person is not giving the money on time, I told you the very important principles of defaulter. The defaulter comes in the picture, and again a litigation begins. Again a litigation begins. So she said that how, as a banker, she found that even a simple instance of a check bouncing, she had to visit the head office, and on behalf of the Bank of Baroda, she visited the legal department, and how she she helped that particular person to get the remedy. Similarly, if she as a banker gives money or loans and advances, is one important function of banking. So when we speak about the Banking Regulation Act, we will be doing important terms in banking technology, terminology, I'm sorry, banking terminology. You will be learning exactly what is the importance of loans and advances, why a license is, of a particular bank can be cancelled by the Reserve Bank of India. So we will be also doing the Banking Regulation Act, wherein certain powers of the Reserve Bank of India you will be learning pertaining to this particular aspect of the SARFESAI laws also, where NPAs were a very serious, issue amounting. You saw, you may be aware of the simple cases of Kingfisher, Sahara, but there are thousands of cases that the bankers need to follow through the legal department when their loans are not being paid, when their loans are not being paid. So basically, when a banker is accepting money from the public, and that money she earns to increase it, and so that's the only way she can earn her interest rates from giving it in loans, in format of loan. And for example, if that loan itself, the other party, the person who has received the loan, is not paying, then it becomes a headache to the banking industry. There's no option than to move the court. So as it is here also, we say is ubi jus ibi remedium. When there is a right, there is a remedy. It's very easy. When you have a right, anything under any laws, we having two types of laws. In my first lecture, I explained to you we having two types of laws. One is the substantial law and one is the procedural law. So substantial law, maybe it's the Foreign Exchange Management Act, maybe it's the SARFESAI law, maybe it's the contract law, maybe it's the simple banking law you're learning now. So it gives a right to every party involved. So just now Uma was explaining to you the right of a person who was aggrieved that somebody issued a check and he was shocked that he's not going to get his money back. So the remedy was the civil and the criminal code. Here also, Uma used to previously go to the Debt Recovery Tribunal. So we as lawyers used to go to the Debt Recovery Tribunal. We used to put up a plain petition saying that. So again, the DRT is just like a court under the civil procedure law, but it's a quasi-judicial authority, and it had only the powers, inherent powers under the civil procedure code, to give the banker permission to attach that property. So for example, Uma is the banker, so she will get the power to attach my property, or maybe the person who is defaulting to pay the payment, that particular person can be yes, that security which has been given, collateral, she used the exact word as a banker. That's what I like in my students, See, they are wanting to express themselves as one of the best. She used a particular word even which I as a teacher and a lawyer did not use. That's the collateral security. Okay. So when you go for interview, see to it that you're utilizing some extra words. So these particular laws will give you the extra words that you can speak out when you are outside seeking an appointment, or maybe seeking as a professional. Maybe you will start a asset reconstruction firm. Maybe you're going to become a one-person company that you're going to help someone you will be getting contracts from the banks that I will do for you the asset, I will get for you back the asset. So there are so many people, even in they come to us as lawyers also, ma'am. We are a asset reconstruction company. So what does an asset reconstruction company do? So that's particularly the law for you, SARFESAI Act. Maybe one day, if you all are wanting to start on your own and you're perfect in your banking and finance, you may start. You may get contracts from banks. Ki baba, these are our MPA, so try to get it back for us, try to get it back for us. So in layman term, we use that the bankers are behaving like, behaving like gundas. They are taking away our mortgage property, they are taking away our vehicles. No, it is not that they are behaving rude. It is a law that has been given under the Banking Regulation Act, that if Uma is not performing her duty as a banker properly, if she is not following the classification of assets properly. So very, very important term over here for the banker is the classification of asset. How is an asset classified? And if Uma feels that this is going to be a doubtful asset, right from the moment it is substandard asset, she starts initiating the process under the new law, that's the SARFESAI Act 2002. So this is the power given to the banker, the power be given to the banker because of the rising amount of NPAs. And as I said, this is something which is people's money involved, and money laundering happens. The people are not the bankers. In most of the cases, we find that bankers were not following the rules also. Even the priority sector lending norms that is issued by the Banking Regulation Act, and the Reserve Bank of India supervises under the Banking Regulation Act whether the priority sector lending has been formed or not. So you will see, when I was in the credit monitoring arrangement, we used to see that, for example, Reliance was the only person from all banks. So I used to monitor, which bank, which particular person or which particular corporate is getting 10 crores and above. So for example, my laptop used to be showing who's getting 10 crores and above. So that was particularly, we used to see that is, yes, the Reliance. So naturally, each and every bank used to give them the loan. So if that loan is not paid on time by the Reliance, naturally they have to follow the procedure. The remedial procedure is approaching the debt recovery tribunal. I was practicing in the debt recovery tribunal, there was so much of mess in the DRT that even the quasi judicial authority used to, okay, Tariq, next date, and the manipulation was so much that people used to think that, yeah, take a loan from the bank, and it will go on in the court, and one fine day we can make a settlement aspect, and yes, in the court the settlement is agreed, so fine, this all things used to happen. So this is a rising cause of worry, not only to the regulator, that's the Reserve Bank of India. So you will find the new law that is passed is the SARFESAI law. So actually, people who are going for marketing or maybe HR, they may think, "Arey, what is this?" Yeah, no. But if you're going to market the banking, maybe loans or maybe whatever, maybe the credit cards, even the marketing students will have to speak about the SARFESAI also. So today you will be seeing some of them as team leader Viper. They will be speaking to you the importance of why the securitization law is important, and why, rather than wasting time in the courts, this particular law gives the banker the power to attach the security, the collateral security that was issued by the borrower has given away the security to the secured creditor. So number one is to regulate. Any law which has been brought out is only with the purpose to regulate. So if someone will ask you, why is the SARFESAI Act come? So you can use the word, maybe you are not a fully a law professional, but you, as a banker, as a finance expert, you can utilize the word to regulate the securitization and reconstruction of financial assets. So they might ask you, what is the asset? Then you need to explain about what is banking and what for a banker is the asset. It's of course the loans and advances. And once the loans and advances are defaulted by the borrower, then this is the particular law which is very, very important: enforcement of the security interest. Enforcement, that is legally the legal action taken by the banker. So this particular act is given has given the power to the banker to enforce his right. For example, if Vaibhav is the deputy general manager and Uma is working under her as the manager, so she will take the permission of her higher up and she will start initiating the process. So, Vaibhav will be giving the signatures. Okay, now you can start the process of enforcing the security interest. So she will start the process of enforcement. So she doesn't have to, knock the court for justice. She doesn't have to knock the court for justice. She just have to start the procedure. She can start giving a notice. She will start issuing a notice as a manager of the bank. That is that she, within such and such day, if you are not paying the EMI along with the interest and plus whatever the bank expenses, the manager might come home 10 times and then you are not, then they might have given to some other agent. That agent has to be paid. So all this amount can be claimed when she is attaching the collateral security for auctioning that particular property. So number 3 is matters connected therewith are incidental thereto. So these are the full-length questions that's expected for your finance laws. Why the formation of SARFESAI Act is there? Number 1, to regulate. Number 2, to enforce. Number 3, matters incidental thereto. Connected and incidental. Any matter which is related to if she has given a loan to a auto fellow, so mortgage, so he isn't paying, so she has the right to send, even on the road you can tell her. Now you can see an auto fellow, if he comes to know that I'm a lawyer, he tells her, hey mama, मुझे टेंशन आ रहा है, मेरा ऑटो कहीं पे भी रुका देंगे उन लोग. मैं बोला क्यों? अरे बैंकर पीछे पड़ा है, मैं कुछ 4 महीने से पे नहीं कर पाया, I couldn't pay, so the banker is having as made an agent, and the agent bike में आके सीधा सीधा मेरा ऑटो लेके जाता है. So these are the rights. So can you file a police complaint? No, because under the SARFESAI law, the manager has a right to appoint an agent. Manager herself will not go on the streets. Yeah, she may accompany the car, the bank vehicle will be there. She may accompany that particular person, but she has a right to, her assets. So this is matters, connected and incidental. Any matters which is connected and incidental thereto, it can be under the SARFESAI Act. So you will find the SARFESAI laws. There are amendments also. That is the importance of DRAT will be there. They might ask you a question of what is DRAT. That's a Debt Recovery Appellate Tribunal. I told you in my first session of justice delivery system in India. The justice delivery system in India says that if, for example, some depositor feels that the order of the DRT is not proper and he is prejudiced with the order of that judicial officer, maybe I am the judicial officer of Debt Recovery Tribunal, and he is not happy with some exemplary payments I ordered to be paid to the bank, so he may go into appeal. So that is the appellate jurisdiction. So under the appellate jurisdiction, we are having the recovery of debts due to banks and financial institution. Number 1, the Indian Stamp Act. The stamps have to be paid before a petition is being heard. We need to affix the stamp. The lawyers do it, and the Depositors Act, and for matters connected thereto or incidental thereto, these are the actions to be taken under the main law, that is the Securitization and Reconstruction of Financial Enforcement Act, the SARFESAI Act. So this can be a small length question, but we are expecting a full length case study for you on SARFESAI law. So yes, very, very important. We had the Sikh Industrial Companies Provision Act. So in the Reserve Bank of India, when I was working for the Industrial Export Credit Department, I had a section called the Sikh Industrial Department. We had a section called the Sikh Industrial Department. I remember, like Uma is explaining to you one of our experience. I had the experience of seeing the file of Amitabh Bachchan, ABCL, when I was in the Reserve Bank of India and the Export Credit Department, we had this department called the Sikh Industries Department, you know, and there ABCL, Amitabh Bachchan, yes, had a it was around, when this SARFESAI Act was not there. I think so. The bank was Canara Bank. I don't remember the bank, but the property mortgage was his Pratiksha, the bungalow, which is there now. And you know, Pratiksha is so important heritage of Mumbai. It is owned. Everyone, you know, every weekend the tourists come and just to see his hand in Pratiksha. Everybody, you will see the tourist buses standing there. So it was like, you know, he would put the mortgage for only just 1 crore or something. He had put the mortgage, and the bankers were preparing to initiate legal action against him. So one of the criteria was, you know, under the Sikh Industries Act, such companies can, you know, file a petition to the particular regulator that consider us as a Sikh industry, so that some other company, some other banker may step into the shoes of Canara Bank, you know. So ultimately, there was this suggestion, and Reserve Bank of India from the Sikh Industrial Department involved, and another bank stepped into the shoes of Canara Bank and took over that particular loan, and that way Pratiksha, his bungalow, the mortgage property, got saved, you know. So you will see that he started in a big way, and for him it's nothing now, you know. He has now 4 bungalows in that area. So there was a chance given by the regulator under the Sikh Industries Companies Act. You know, this is one case which I would like to, as my experience in the Reserve Bank, this very, very important law was there. That is the Sikh Industrial Companies Act. But it was seen later on stages that so many companies using their influence, seeing to it that bankers are taking away. That's called the doctrine of subrogation, that is stepping into the shoes of another. So if, for example, Canara Bank wants to, rectify this particular loan, another banker is requested, and that banker will give the money to the initial secured creditor. And yes, the document is again handed over to the new banker, and a new contract comes in between the depositor and the loan person, the person who has taken the loan, and the banker. So these are very, very important provisions when people are termed as willful defaulter. He didn't have an intention of being a willful defaulter. It was those stages of his career where he wasn't having that KBC and all. Then you saw ultimately he started, working so hard. People used to tell, Arey, is found in an advertisement also. It's not because of that. It is because of the fact that he need to rotate his finance, and he used to see to it that, yes, his saving is very, very important property, which has been given as a collateral security to the banker. Yes, I think so. It was Canara Bank. If you see the ABCL case, you can see this. So this is the Sikh Industries Department we had in the Reserve Bank of India. So after that, we have the RBI scheme also, where the corporate debt restructuring and strategic debt restructuring is done. So when we do the Reserve Bank of India, we will see the corporate department over there, where such requests are coming. Under even now the SEBI takeover laws also, you will see how the governor, Dr. Raghuram Rajan, had issued a statement saying that rather than closing a company and the depositors, maybe the shareholders' money, maybe the person who have given credit to that particular company, losing the entire amount, let us allow for a merger and acquisition. Let us allow a takeover. So these are the things that if a particular defaulter isn't not in a position, so these are the restructuring scheme that is from the Reserve Bank of India. Afterwards, we had the recovery of debts due to banks. Then we had the SARFESAI Act 2002. I told you the rising number of NPAs. The Reserve Bank of India, along with the Government of India, passed this law that rather than wasting time in the Civil Procedure Code and again winding up of a company, going up to the Supreme Court and the appellate jurisdiction, take time. It takes so much time that the defaulters used to enjoy, the defaulters into it. And you all know now, as learning, last 7-8 sessions of contract law, company law, insurance law, banking law, that wherever justice is delayed, yes, justice is denied. Wherever justice is delayed, justice is denied. So the basic principle of why the SARFESAI Act is enacted is giving justice on time. So Uma Karandikar, as the manager of Bank of Baroda, will have the power to issue notices and attach the property of that particular defaulter. And the procedure she will be following, yes, of course, it's a banking law procedure and the code of civil procedure. She will get the powers to auction it, and how as a right the auctioneer, and she also has the right, to give away this contract to a company which has been formed as a asset recovery company. So all these things will be explained to you by the SARFESAI team that's headed by Viper. Okay, so applicability of SARFESAI Act is very important. Number one, regulate. I told you any law you need to use the word regulate. Regulate the securitization and reconstruction of financial asset and enforcement of the security interest. So what she is doing is, though she is not a lawyer, but she has been given the power of the judicial, quasi-judicial authority to start enforcing the security. So she starts the legal process. Therefore, number two is enforcement of security interest. Number three, yes, provide a central database of security interest created on property rights and for matters connected thereto. So regulation of asset reconstruction company by the Reserve Bank of India, facilitating securitization of financial assets of bank with or without the underlying security. So very, very important is our Reserve Bank of India, that is registration and regulation of an asset reconstruction company which enters into contract with Bank of Baroda. And she has the right, Uma will have the right to give entire authority to this asset reconstruction company to follow the procedure. So the Reserve Bank of India, under the Banking Regulation Act, facilitates the this particular companies which has been issued license. Yeah, now promotion of seamless transferability of financial asset by ARC. So if that particular asset reconstruction, or particularly a case has come to me right now, a particular case has come to me right now. He is the owner of three companies. He's the owner of three companies. That is, he's actually a one-person company. He has started the company in his name of his wife, and now he has started the company in name of his friend also, who is a lawyer. So three companies he has formed. Only his basic aim is the asset reconstruction company. He enters into contract with banks and whatever NPAs is there, he just sees to it that he is utilizing this law and he interacts with that particular, defaulter, and sees to it that any out of court settlement can be done or not. So these are the things that asset reconstruction company does. So entrusting the asset reconstruction company to raise funds by issuing a security receipt to qualified buyer, facilitating the reconstruction of financial assets which are acquired while exercising powers of the enforcement of securities. So naturally, the asset reconstruction company is facilitated acquiring the exercising of powers under the SARFESAI law. So presentation of any securitization company or asset reconstruction, again registered with the Reserve Bank of India as a public financial institution. So defining security interest, that is very important. Any type of security, any type of mortgage, any type of charge on an immovable property, any charge, we'll be doing in our next session. After the banking and financial laws, we will be doing the property laws. We'll be doing the property laws, and in the property laws, we will be doing what do you mean by, charge? What do you mean by mortgage? All these things are extremely important for a banker. Unless and until she takes a proper collateral security, her money is not safe. The banker's money is not safe. So for example, if she is giving a lorry on hypothecation, or maybe a truck on hypothecation, so naturally you will find that a board is written behind the vehicle. This particular vehicle is hypothecated with Bank of Baroda. You can see on the streets, So even such things also comes under the Securitization Act. So what do you mean by a security interest? What do you mean by a security interest? That is, Uma Karandikar has a type of security. It may be a mortgage, it may be a charge, it may be a charge on an immovable property, it may be anything that is related to repayment of financial assistance given by the banker. So it's very easy as a banker, हमारा पैसा हमें वापस मिलना चाहिए. आपको क्या मिल रहा है कायदा में? Yeah, You don't have to go to the debt recovery tribunal. You can start your process, and the banker is not going to tell you all these things. The banker will only make you sign the documents when you take the loan, that she has got the powers to take any action if you are not paying the EMI on time. So this is that presentation of any securitization company registered with the Reserve Bank of India as a public financial institution, defining the security interest to be any type of security, including the mortgages, charges it is charge on the immovable property given for due payment of any financial assistance given by Uma Karandekar, okay, from the Bank of Baroda. So you will easily understand because as a banker in your friend right now. So securitization and reconstruction is an Indian law. It allows the banks and other financial institutions. See, in this law, you can, along with the banks, always tag the financial institutions also. Any financial institution has the right to auction residential or commercial property to recover the loan when a defaulter is, having a breach of contract. So where any borrower who is under a liability to a secured creditor, please use the perfect words. Where any borrower who is under a liability to a secured creditor, that is she, the Bank of Baroda is the secured creditor. Under a security agreement, we did the contractual clause in the law of contract. So naturally, when she is giving the loan, she makes them sign various contractual clauses, and one clause will be this, that is, she is a secured creditor and you will be liable for proceedings under the, they will not write SARFESAI Act. They will be writing over there, you will be liable for whatever legal action to be initiated by the bank in case you are a defaulter. So any default or repayment of secured debt or any installment thereof. Okay. So is account respect of such debt is classified by the secured creditor. Now secured creditor is the Bank of Baroda, but the classification laws are issued by the notification from the Reserve Bank of India under the Banking Regulation Act. I said it is the standard asset, substandard asset, doubtful asset, and the losses. The final is the losses. So ultimately, before it becomes a loss, she initiates the process of adjudication of that particular property. Okay, that's enforcement of her rights as a banker. So she will start it, she will attach it, she will auction it, and she will recover the loans. So this is the amendment to the Act. A central database of security interest created on property rights is there. Yes, and all matters thereto and incidental thereto. So this is usually a banker's right. It's usually a banker's right or a financial. I told you, whatever your answer is, always with the banker, mention the financial institution also. Always with the banker, mention the financial institutions also. So along with the banker, any financial institution has a right under the SARFESAI law. Any financial institution has a right under the SARFESAI law. So a very, very important boon to the bankers it is, rather than going to the DRT. So what do you mean by a DRT? Can an expected question? So your friends will be now explaining to you the DRT. The working of the tribunal is similar to the court, and again, the civil procedure code will be followed. I told you, in the civil code, it's a civil procedure code. In the criminal code, is the criminal procedure code. Again, we the lawyers put up a petition, and the particular banker is the petitioner for me. The particular banker will be the petitioner. I will write the petitioner in the debt recovery, judicial officer. He will accept it if all the terms and conditions are proper. If everything I'm showing proof exactly what the bankers give me, I put it to the DRT, and yes, the DRT accepts the petition and summons are issued to the defaulter. The defaulter has to appear in the court and mention through the written statement why exactly he defaulted the payment. It's the same procedure followed in any offenses under the civil law, whether it's defamation, whether it is trespass, whether it is whatever. So the procedure followed will be same. The lawyers apply, the defendant lawyers come, they write the written statement, why crores of rupees were defaulted, what has happened to the market scenario right now, that particular person is not earning anything. So naturally this has become an NPA. So it's up to the discretion of the court and the bankers also to, now we are expecting more and more litigation after this pandemic. Too much of debt recovery cases are going to come up to the banks. People are not in a position to survive, so how are they are not in a position to pay back their loans also, but the interest is mounting. So there's going to be a definite rules which a Reserve Bank of India will come across, because it's going to be difficult for the bankers to recover the loans that has been given to the public also in such cases of pandemic. So you can see litigations too much will be coming, and to just not to have this DRT process, we having this SARFESAI law. But in SARFESAI law also we'll see the disadvantage that, for example, if someone has taken a loan and is staying in that house, and now because of the pandemic he has lost his job, so how can he be thrown out from that SARFESAI? So under the SARFESAI law, she has a right to seal the flat. Where will he go? So these are the things that are going to come up in the new in another 2-3 months for the bankers also. So the Reserve Bank of India may come out with a circular, so that something good is happening not only to the persons who are taking the loan. So these are the appellate tribunal. In appellate tribunal, if appeals have to be filed, I need to deposit 20% of the amount which has been ordered by the judicial officer of the debt recovery tribunal. So if I am the judicial officer of the debt recovery tribunal and I have asked a particular defaulter to pay by Bank of Baroda 60 lakhs, so 60 lakh or 20% I have to deposit. She has to deposit to the DRT, and then the DRAT, that's the Debt Recovery Appellate Tribunal, will accept my petition. So these are the procedure. They will be explaining to you the procedure. That is, yes, the borrower, he is giving the security to Uma Karandikar, and Uma is, yes, giving permission to the asset reconstruction company. So the bank will secure the asset transfer to the ARC. The ARC will give the security receipt to the qualified buyer. And yes, the qualified buyer purchases my flat, may give 80 to 90 lakhs to the asset reconstruction company. And this asset reconstruction company gives the cash to the banker. So this is the process, financial assistance, how a asset is reconstructed by a ARC that is given license by the Reserve Bank of India under the Banking Regulation Act. So you all understood very, very important banking laws, not only the SARFESAI law, but the RBI law, and also the, yes, Banking Regulation Act, which gives all this power to the regulator to, yes, how under the SARFESAI law, and also the Insolvency and Bankruptcy Code. If you see the latest case, I'll be making somebody do the research on a very famous case right now. That particular personality was not allowed to fly out of the airport. Yeah, that's the Jet Airways case. Hai? So you will see the Jet Airways case. This case is now gone to the Insolvency and Bankruptcy under this code. They want to be declared as an insolvent, so these are certain provisions of law where the court interferes. And one of you, I'll be making you all do the Jet Airways in the insolvency proceedings, how the insolvency proceedings takes place. Insolvency and Bankruptcy Code is a transformational piece of legislation that seeks to establish an ecosystem for handling insolvency and bankruptcy issues. So even Jet Airways has been, so many, like you saw the present case that's going on, that was a crime that had happened. So how in a crime scenario, the ED has entered. So Enforcement Directorate has entered into a criminal scene. Why? Because there has been transfer of current assets and capital assets outside the country. Maybe it's through a tax haven. So such people are accused of using money laundering, activities. So therefore, the Enforcement Directorate wanted the custody of the Jet Airways owner. The Central Investigation, they also wanted his custody. So you saw all of them in the Supreme Court, again, that this particular person should not be allowed. So when he, as a person, he felt that he was not allowed to fly. Jet Airways person was not allowed to fly. I'm not taking his name often, but you all understood who is. He was not allowed. He was not allowed. Dr. Naresh Goyal, right? Yeah. So he was not allowed to fly out of the country. So he was thinking that his right to fly away is not an Indian citizen, he's an NRI. He was claiming in the Supreme Court also that he is not an Indian citizen, he is an NRI. So why is he not allowed to go back to his country where he is the citizen? So, but we are having certain rules and regulations where our transactions are shown as, yes, foreign exchange, and this Reserve Bank of India, when they are making rules and regulations pertaining to exchange control, we having the exchange control department in the RBI, which makes the law. Similarly, this enforcement directorate people was behind the Jet Airways people, and therefore they thought that the best thing that they do is approach a court and utilize the insolvency proceeding advantage. So most of these corporates, they start using this advantage of insolvency and bankruptcy code. So this is very, very important. That is, any stakeholder, any individual, any partnership firm, apart from century-old legal framework, that is, it's a game changer in which the banker, the court, the investor, the banker, the court, and the investor initiates an insolvency proceeding. So there can be a question for you on the insolvency and bankruptcy code. You should not forget the three important persons there. You can remember Uma Karandikar from Bank of Baroda. You can remember me, the court, and you can remember the investor who has lost his money. So all these persons are the initiators of insolvency proceedings. They have a survival plan. What does the court help them to do? The court will help them to settle the case in harmony. There should be a harmonious settlement of a dispute which is arising because, yes, he was not allowed to go because inability to pay debts, yes, Jet Airways is in loss, and therefore the insolvency proceedings have been initiated in the court. So you will see a survival plan is given to those people, these corporates, yes, or liquidation of the sick units and facing, other than facing the willful defaulter. So they can liquidate their assets also. Yeah, so this is the SARFESAI law. The key difference between the DRT and SARFESAI, under the, yes, recovery of debts due to banks, under the Recovery of Debts Due to Bank Act, recovery of debt is made through quasi-judicial bodies called the Debt Recovery Tribunal, whereas under the SARFESAI, only the secured debts secured by way of underlying the assets can be recovered. The minimum debt amount to approaches 20 lakhs and above. So your friends will be speaking on it. So SARFESAI law, yes, this is the limitation, 1 lakh. So non-performing asset loan accounts where the amount is less than 20% of the principal are not eligible to be dealt under the act. So that particular person has made 80% of the payments, only 20% is left. So such things will not come under the act. So yes, monetary limit is 20 lakhs. So your friends will be speaking on that. Yes, asset classification. I told you the substandard asset, the doubtful asset, and the losses. Yes, this is the SARFESAI, the role of the SARFESAI Act. Securitization, number 2, reconstruction, number 3, enforcement, and any other functions that is which will help the public money to be not gone as lost. Yes, so case study we'll be doing whether civil suit is maintainable, whether proceedings under SARFESAI Act. This is not so important to you as this is a Supreme Court case study which has been given over here. Wherein, arriving at a decision, the court made reference to the case of Jagdish Singh versus Hiralal. It was held that the remedy of any person aggrieved by initiation of proceeding under the SARFESAI Act lies under the securitization law, which provide for quick disposal, quick remedy to the aggrieved party. So even the Supreme Court is saying, yes, the banker has the power to, yes, seal the asset or attach the asset and get back the money. So yes, they will be speaking to you this. Yes, yeah. These are the appellate jurisdiction of the Supreme Court. It is. You can see the Supreme Court of India there. So under the Debt Recovery Tribunal, it goes to the court, district judge. From the district judge, it goes to the High Court. From the High Court, it goes to the Supreme Court. So very, very important it is. The bankers finally appear in the Supreme Court. If any case, they cannot withdraw the, yes, they cannot withdraw the money. Yeah, so the Supreme Court bench in this case also said that the secured creditor shall consider such representation or objection. If such representation or objection is not accepted, he shall communicate the reasons for non-acceptance of thereof. That means if Uma is giving a notice to a defaulter, maybe the defaulter is Jet Airways or maybe Kingfisher. If she is giving a notice on behalf of Bank of Baroda, and if they are representing that please wait, this is something happening and we are going to get back our money and we will give it to you fast. And if she is not ready to accept this, because she is answerable to the Reserve Bank of India, if it becomes a non-performing asset, she is answerable to the inspection team of the Reserve Bank of India. So there is the Supreme Court says that she the banker shall communicate the reasons for non-acceptance thereof. So she will write the reasons that I'm sorry, we are not, inconvenience is deeply regretted. Under the SARFESAI law, we the bankers are supposed to take immediate legal actions, and therefore we are attaching your property or we are sealing your property. So this is the Supreme Court bench which has mentioned that the banker has to communicate the reasons where a non-acceptance is given of the notice that we are going to attach your property. Okay, so yes, that's the rising number of non-performing asset, a very serious issue with the banks. And because of this scams and cases, in innumerable cases that has come up in the court, the SARFESAI Act has been enacted, and the Reserve Bank of India, from the supervision department, that is the Department of Banking Operations, we'll see it is divided into Department of Banking Supervision and Department of Non-Banking Supervision. So when they send an inspection team, for example, our captain, okay, Vanshika, she is going from the Reserve Bank of India to inspect Uma's bank, Bank of Baroda. She will see to it whether Uma has taken action as per the SARFESAI law. So if Uma has not taken the action as per the SARFESAI law, she, as the RBI, will have a power to intimate to the governor, and the governor will start, along with the legal department, will start initiating action. Why there is rising number of cases in her bank? What mean? Why? So she has to come and answer it to the particular, regulator. We invite them happily, but in fact, we are inviting them to take legal actions and legal proceedings under the Banking Regulation Act. So the rising number of NPAs and the bankers not taking serious action and the DRT process being too slow, yes, led to the SARFESAI law. Okay, so Vaibhav and his team will be able to do it today. Vaibhav?
Yes.
Yeah, come on, start. We can finish it off. Yeah, thank you. We can finish it off today. The SARFESAI law. Yeah, I'll stop the share. Yeah, thank you so much, Vaibhav. Yeah. So that's the SARFESAI law. Very, very important for your exam. Yeah, and also for your career. As a career.
Ma'am, you'll have to make me the.
Oh. Now how can I do that?
I'll do it.
Okay. Yeah. Thank you so much.
There's 5 of us.
Yeah, we'll finish it off today.
With talent borrow. So Vaibhavi will start.
Vaibhavi is going to speak. Yeah, the SARFESAI. Yeah.
So my name is Vaibhavi Taylor. I'll be explaining about the objective of the SARFESAI Act and the section 31. So basically, SARFESAI Act was passed on 17 December 2002 in order to lay down processes to help Indian lenders recover their dues quickly. So SARFESAI Act empowers the bank and the financial institutions to auction their residential and commercial properties that have been pledged with them in order to recover their due loans. And before SARFESAI Act, the financial institutions had to take the recourse to the civil courts in order to recover their dues, which was the lengthy and time-consuming process. And the Supreme Court recently held that the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement Security Interest Act 2002, that is SARFESAI Act, will be applicable to cooperative banks and not just the commercial banks. So overall, SARFESAI Act 2002 gives the seizure power to the banks, and the bank need to issue the notice in writing to the borrowers, which insisted them to
Pay
discharge
back.
of the liability after 90 days of default
Yeah.
if they are not able to repay their loans.
Yeah.
Then
Correct.
talking about the objectives of SARFESAI Act 2002,
Yeah.
so slow recovery rate of loans and the high level of non-performing assets led to the formation of the reform, and
Yeah.
Narasimha Committee 1 and 2 that was
Yes.
constituted by the central government
Yeah.
uh, brought
Suggested.
brought in the modification in the legal system.
Yeah.
And another objective is efficient or rapid recovery of non-performing assets of the
Yes.
banks and FIs.
Yes.
They allow the banks and financial institutions to auction their properties when borrower fail to repay their loans.
Yes.
Then granting financial institution and banks the ability
Yeah.
to secure the interest without intervention from the court. So they
Yeah.
have the they don't need any lawyer or tribunal.
Yeah.
And talking about the applicability of SARFESAI Act, so
Yeah.
the provision of this act apply to the outstanding loans
Outstanding loans and advances. Yeah. Correct.
which are classified as non-performing assets. It
Yeah.
deals with the registration and regulation of ARCs, that is Asset Reconstruction Companies, by the
Very good.
Reserve Bank of India.
Yeah.
Then entrusting the asset reconstruction companies to raise funds by issue of security receipts to qualified buyers.
Yeah.
Last is the deal with the reconstruction of financial assets.
Yeah.
Next slide.
Correct.
Next slide. So now talking about the section 31 of SARFESAI Act. So
Yeah.
this section deals with the provisions of SARFESAI Act which shall not apply in certain cases, such
Yeah.
as lien on any goods, money or security given by or under the Indian Contract Act 1872, the
Yeah.
Sale of Goods Act 1930, a pledge of movables within the meaning of section 172 of the Indian Contract Act 1872. Then
Yeah.
creation of any security in any aircraft is defined in the clause 1 of section 2, the Aircraft
Yeah.
Act 1934, and
Yeah.
non-performing asset loan accounts amounting to less than 20% of the principal and interest are not covered under this act.
Yeah. Correct.
Further will be explained by my teammates.
Yeah. Correct. Yeah.
Hello,
What
Varun.
happened?
Yeah.
Hello.
Yeah.
Varun, it's your
Vaibhav, you can continue if any issue.
Hello.
Yeah.
our
Some of the important terms in the SARFESAI Act and their meanings are like what is securitization? So according to section 2(1), C, acquisition of financial asset by any securitization company or any reconstruction company
Yeah.
from any originator, whether by raising of funds by any securitization or reconstruction company from qualified institutional buyer by
Yeah.
issue of security representing a financial asset. In
Yeah.
simple
Correct.
terms, securitization is nothing but, I'll give you an example of SBI.
Yeah.
SBI being a bank will go
Yeah.
to any NBFC who is in financial distress and has some liquidity issues. So
Yeah.
the NBFC is going to sell its current assets, and its assets will be loans given to the other people,
Yeah.
to its clients.
Yeah.
So SBI will buy the loans that are given out, and a certain percentage will be its profit
Yeah.
over the transaction for the SBI.
Yes.
Then what is asset reconstruction?
Mm.
Section 2(1)(b) says that asset reconstruction means acquisition by any securitization company or
Yeah.
reconstruction company
Yeah.
of any right or
Yeah.
interest of any
Yes.
bank or financial
Yes.
institution in
Huh.
any financial assistance for the purpose of realization of such financial assistance.
Yes. Correct. Yes.
Next slide, please. What is a security interest?
Very
According
important.
to section 2(1) ZF,
Yeah. Yeah.
security interest means the right, title,
Yes.
and
Yes.
interest of any kind whatsoever upon property created
Yes.
in favor of any secured creditor, and
Yes.
includes any mortgage, charge, hypothecation,
Yeah.
assignment other
Yeah.
than those specified in section 31. So
Yes.
security interest is nothing but the collateral that is given to the creditor.
Yes.
And what is a non-performing asset? An
Yeah.
NPA means an asset or account of a borrower
Yeah.
which has been classified by a bank or financial institution as a
Yeah.
substandard.
Yeah. Correct.
So substandard is nothing but a doubtful to recover or will not be able to be recovered.
Yes. So you as a
So
banker is classifying it as a substandard as well. Yeah.
yes, like for PNB, Vijay Mallya is a NPA right now. What is a reconstruction company? Section
Yeah.
2(1)(v). Reconstruction company means a company formed and registered under the Companies Act
Yeah.
1956 for
Yes.
the purpose of asset reconstruction.
Correct. Yeah.
Next slide, please. Uh, what is a securitization company? Section 2(1)(za).
Yeah.
Securitization company means any company formed under or registered under the Companies Act 1956 for the purpose
Yeah.
of purpose of securitization.
Correct. Yeah.
What is an appellate tribunal? Section 2(1)(a). Appellate tribunal means a debt recovery appellate tribunal established under the subsection 1 of section 8 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993. It
Yeah.
is the place where where the uh, debtor can appeal in the appeal for its amount recovery.
Yeah. Correct. Correct.
What is a borrower? Section 2(1)(f). Borrower means any person who has been granted financial assistance by any bank or financial institution, or who
Yeah.
has given any guarantee or created any mortgage or pledge as a security for the financial assistance granted by
Yeah.
any bank or financial institution, and
Yes.
includes a person who becomes borrower of a securitization company or reconstruction company
Yeah.
consequent upon acquisition by it of any rights or
Yeah.
interest of any bank or financial institution in
Yeah.
relation to such financial assistance.
Correct. Yeah. So that's a financial assistance given to the
What is a
company.
bank?
Yeah.
Section 2(1)(c).
Yeah.
A bank means a banking company or a corresponding new bank or the State Bank of India
Yeah.
or a subsidiary bank or
Yeah.
such other bank which the central government may by notification specify
In this
for the
official
purposes of
gazette.
this act.
Yeah. Correct. So these are the important criteria. How the recovery take place. Very important. It is excellent. Okay. It's excellent project. It is. Yeah. How the recovery take place.
Good evening, ma'am.
Yeah.
My name is Udip, and I'm going to explain you the 4 ways how the recovery can take place.
Yeah.
So these are from the perspective of a bank manager.
Yeah.
So the first one is you take possession of the secured assets of the borrower, including the right to transfer by ways of lease, assignment, or sale for releasing the secured assets.
Yeah. Correct.
The second way is take over the management of the business of the borrower, including the right to transfer by ways of lease, assignment, or sale for releasing the secured assets.
Yes. So you as a banker can take over the rights if you can give that property on rent.
Exactly.
If he has already given it on rent, you can take over the rental receipts from next month onwards.
Exactly.
Yeah. Next month.
So the third way is you can appoint any person to manage the secured asset, the possession of which is taken over by the secured creditor.
Yes, correct.
The fourth way of doing it is you can at any time send a notice in writing to any person who has acquired any of the secured assets from the borrower and from whom any money is due or may become due to the borrower.
Can you give me 1 minute? Can all the negotiable instrument people also come on the screen, please? All the banking negotiable instruments, all those people who presented on negotiable instruments, I request you to be there along with them so that they will understand, the class will understand the very, very important 2 laws that they spoke today. Okay? Yeah. Where are the others negotiable instrument? Okay, come on, start. Yeah.
Okay. So the bank manager also has some important roles that we need to take a look at.
Yeah.
So the first one is the possession notice. you as a manager are empowered to give a position notice.
Yeah.
So the section 14 of the SARFESAI Act states the chief metropolitan registrar or the district registrar can assess the secured creditor in taking possession of the secured asset.
Yes,
the banker in this case need not appoint a lawyer for the particular problem.
Yes, correct.
Next.
So
And
there's
also the section 17 of the SARFESAI Act, which states the hierarchy. We've not added it in the thing. But then the hierarchy from the top starts off as Supreme Court, High Court, DRET, and then DRT.
The Debt Recovery Tribunal, the Debt Recovery Appellate Tribunal, the High Court, and the Supreme Court. Very, very important it is. As bankers, you all need to know this.
So depending
on the power given to you as a banker, it is to next after 2-3 years, maybe you all will be telling me, I'm in the ICICI Bank, maybe you're in the IDBI, maybe you're in the IFCI Bank, These are my students who have already reached all these places, right? So tomorrow you people may be there in that place. So you're supposed to know the hierarchy of the courts also. Maybe your bank manager, the CMD may send you to the Supreme Court as a banker representing that particular, action you took. The action you took, you may have to fly to the Supreme Court also as an assistant general manager. So you need to know the procedure of the, enforcement of security rights under the SARFESAI law. Yes.
So now we'll talk about the DRT laws. Debt Recovery Tribunal were created in 1993 through an act to speed up cases for financial recovery by banks. The banks and financial institutions were experiencing a lot of delays and difficulties in recovering the monies lent and enforcement of securities pledged to them for the loans availed.
Yes, correct.
When the debt due to the borrower is more than 10 lakhs, the case would be filed in DRT.
Yeah, correct. The case will be filed in the DRT.
The working of the tribunal is similar to a court. The borrower who is aggrieved by the order to the DRT can approach the appellate tribunal. Such appeals should be made within 45 days of receiving the order from the DRT.
So the limitation law.
This comes under that. He has to deposit 75% of the amount which is due from him to the bank and financial institutions while filing his appeal.
Yeah, correct.
The appellate tribunal has also got the power to reduce or waive of this amount.
Correct,
The next would be...
these are the disadvantage. The issues faced in the SARFESAI Act.
Good evening, ma'am. My name is Vishal Pednekar. I'll be talking about the issues faced in the SARFESAI Act. So the first is the Reserve Bank of India guidelines in relation to classification of NPAs are not followed